All right. Welcome back to JPR. Today's Friday, February 2nd, 2024. This is our first voting session of the 2024 legislative session. We have 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 bills on the first list. How many bills on the second? 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. And 10 bills on the second list for unfavorable withdrawn. We're going to start off with Senate Bill 575, and we'll have council explain the bill and some of the forthcoming amendments.
Senate Bill 575 authorizes protected individuals or the Office of Information Privacy in the Administration Office of the Courts to request that a governmental entity or person not publish personal information of the protected individual on the internet, social media, social networks, or remove the information from existing publication. It specifies procedures for the protection of personal information of protected individuals. It authorizes certain civil penalties as well as criminal penalties for persons who violate the act. It creates the Judicial Confidentiality Program, and it also creates a task force to study judicial security at judicial facilities around the state. There's an amendment in your packet. There's a chair amendment, and that amendment addresses an issue. It's on page 3, line 19. It adds to employment of an individual described in section E6. And so personal information would not include the workplace of the judge, but it would include the workplace of the judge's family dependents that reside in the house with the judge. There's another amendment. You don't have a copy of that in your packet. Okay. And so the second amendment on that same page adds members to the Judicial Security Task Force, President of the Maryland State Bar Association, Public Defender, Maryland States Attorneys Association, and the Conference of Orphans Court Judges. And Senator Sidnor had another amendment. That amendment, if you go to page 7 of the bill, that amendment replaces the word person with individual. Individual is just one person, whereas person under the general provisions article can mean a corporation, it can mean a partnership, a representative. And so this just narrows it to just the person who publishes the personal information being subject to criminal penalties.
All right. So let's do the First Amendment first, and then Senator Sidnor, do you have a comment on an additional amendment, or is it okay we start just the amendments first so we can go in order? Yep. So you want to move? Yeah. Second. Is everyone okay adopting these amendments? Okay, excellent. So now the bill is before you as amended. Senator Sidnor.
Thank you very much. One of the other things that I had mentioned the other day, and I had spoken with the bill's sponsor, was on page 7 in the new section 3-2304. And that's what I asked our panel about, which was the way that the bill is drafted. It says that a person may not knowingly publish the personal information of a protected individual if, and says the person knows or reasonably should know that the publishing the personal information poses an imminent and serious threat to the protected individual, and then certain things happen. When I spoke with Senator Corderman, during the course of that conversation, I said that it felt like something was missing. And what I thought was missing was that that individual or that person who would fall within this law, that they were not notified to take down that information. And I thought that it would be clear if the person may not knowingly publish that personal information, and if then contacted via, I guess, whomever it is, whatever this agency is that we're creating, then at that point, that you had a crime committed. and there had to at least been an attempt to notify them that they wanted that the information should have been taken down. So that was supposed to be the amendment. We just didn't have enough time to have it drawn up.
All those notifications are gonna be going through the Office of Privacy anyway.
Not necessarily.
Okay.
The protected individual could send it on their own behalf to the individual.
Okay.
But if you want to make the notice more official, just make it through
The Office of Privacy.
it's up to you all.
Can you read what it would sound like?
Sure.
So an individual may not knowingly publish the personal information of a protected individual if they've been notified by the protected individual or the information or the Office of Information Privacy. The person knows or reasonably should know that the publishing the personal information pose an imminent and serious threat to the protected individual, and the publishing of the personal information results in assault in any degree, harassment, trespass, or malicious destruction of property.
Sorry, all right, we've got the amendment is before us, but there's discussion. So we've got Senator West, I'm sorry, Senator James was first. Is it on the amendment or?
No, I'm saying thanks.
Got it. No, keep it on. So Senator West and Senator Bolden.
Thank you, Mr. Chair. So when Senator Sidner discussed this with me in the back, it sounded good, but now that I read the language, I'm thinking of a situation. Let's assume there was a challenge to the validity of an election here. And the person making the challenge had argued the election was fraudulent. And the judge heard the testimony and then concluded the election wasn't fraudulent. And the person went online and published personal information about the judge and said he's obviously an awful individual and he should be done away with immediately. And then somebody goes to his house and does it. So what this says as it exists is a person cannot knowingly publish the personal information if the person knows or reasonably should know that publishing it poses an imminent and serious threat to the protected individual, and the publishing results in something bad. So in that kind of a situation, you wouldn't want to interpolate another requirement that the person be notified that the information should not have been published, because that creates a time problem. And the judge is killed in the meantime.
And that was the one example that Chief Justice Fader brought up. However, again, there's a question of what poses an imminent and serious threat. I mean, the way that I read this, what if I went online and I posted some of this information about the judge? I don't think, I have no idea that one of my colleagues had an issue with him and was posting evil things, and you have somebody out there that then took the personal information that I published for whatever reason I published it, and the idea that this person had about this judge being a type of person who should be taken out. They put this together, and something happens to that judge. Now they're coming after me for publishing under this current iteration of this. I didn't know. So that's the issue that I have with this. I think it's too broad. Now, if you want to specifically go after the type of situation that you're talking about, then the language needs to be tightened up. I have no problem with that, but I think it's too broad at the moment.
So I'm happy to tighten it up, but it seems to me the language right now is pretty severe. It says imminent and serious threat. If you could suggest more stronger language, I'd be happy to consider it, but that's pretty strong. Imminent and serious.
It's in the law. Other places in the law. That's what That's for the state's attorney to prove. To make it something that would be, you get a warning. That's the whole idea behind this bill, is to not be able to feel required to notify someone that, oh, well, we know, so don't do that again. Shamey, because it's too late in extreme circumstances like what happened to Judge Wilkinson. So I think that I understand his intent, but imminent and severe bodily or serious bodily injury or severe threat, those are in the other places in the law, are they not?
Hey, based on the testimony of Judge Wilkinson's spouse, that person, whoever put that in, the person who committed that crime got the information offline. Under this bill, that person would then be prosecuted. Not the person who committed the crime, the person who published it. That's what I'm attempting to avoid by talking about my amendment.
But that's the idea behind this bill, is to have these sites not have that information out there and have it secured so that that's not out there. That is the whole intent of the bill, or a large portion of it.
I actually, I understand where Senator Sidner is coming with this, but I agree that I've seen this language elsewhere. It makes sense to me. It seems pretty, pretty clear, the imminent and serious threat, no, or reasonably should know. I think it makes this, serious, a serious statute that people will need to follow, because it is, sorry, I'm having trouble finding my words because I keep thinking of the testimony we heard on this bill. And I just want to make sure that we are doing the most we can to make sure that this doesn't happen again in the state of Maryland. I'm really comfortable with this language because I've seen it in other places, and I understand the intent and concerns that Senator Sidner is raising, but I don't share them. I like the language as it is.
All right, excellent. So Senator Sidner, what's your pleasure? Do you want to run this amendment, or you'll run it? Okay. So then there's been a motion. We'll give you a chance. So we'll run it on the favorable a vote. So it's motion favorable. So no is to defeat the amendment. Okay. All right.
He doesn't have a second.
The motion, is there a second? But that's true. It's true. Go ahead.
So an individual may not knowingly publish the personal information of a protected individual if, after notification from the protected individual or the Office of Information Privacy, to take the personal information down, the person knows or reasonably should know that publishing the personal information poses an imminent and serious threat to the protected individual, and the publishing of the personal information results in an assault in any degree, harassment, trespass, or malicious destruction of property. And so Senator Sidnor's amendment essentially adds another element to that offense of the person receiving notification, either from the Office of Information Privacy or the protected individual, that the information is personal, that they should take it down.
So
I might ask counsel a question. Essentially, as written, we're creating a strict liability offense just for publishing this information, correct?
I don't believe so. The element that they know or reasonably should know.
That takes away the strict liability element.
And so that's, I think, is the attempt to salvage constitutionality of it so that the person is on notice. It's imminent and serious threat to the protected individual. And I think that's the intent.
Thank you.
all right. Senator Charles, go ahead.
Thank you, Mr. Chair. So right now, if somebody has an address out there that's out in the universe, right now, this law is going to make them allow somebody to force them to take that address off of the website now, correct?
If it's requested, yes.
If it's requested. If it's not requested, it won't be taken down.
That's right.
So this is going to be done across the board. It's going to be swift. Everybody take these addresses off of your websites now. So it's as simple as that. It's already being requested, correct? I just want to make sure. Okay.
Okay, so do we have a second for the motion?
Second.
Okay. We'll run it.
Vice Chair Wildstriker,
No, although I appreciate the intent of the amendment.
Senator Sidnor.
Yes.
Senator West,
No, I also appreciate the intent of the amendment, but
Senator Muse,
Yes.
Senator Folden,
No.
Senator James,
No.
Senator Charles,
No.
Senator Kelly,
No.
Senator McKay,
No.
Senator Carter.
Yes.
Chairman Smith.
No, I do appreciate the intent though.
Appropriate now, Mr. Chairman, to add a sponsor amendment.
Yeah. Any forthcoming amendments we'll entertain?
I'd like to be added to the sponsor.
All right. Senator Folden, Senator.
It was, I'll let her, we've been talking about.
Senator Folden, Senator James, Senator Carter, Senator Kelly, Senator
Does
Waldstreicher.
anybody not want to be on it?
Yeah,
Let's
I
just
think
make it.
So Sans Sidnor.
Okay.
Senator Muse,
Senator Muse
Yeah.
and Senator Sidnor.
yeah, Senator Muse wants to be on. Yes, all right,
Okay, so everyone
separate.
got
Yeah,
it.
yeah. Senator Charles. Sure, yeah, of course. Senator Sidnor would like to speak.
I'd had a conversation with some of my colleagues on this, and after seeing some of the things that I've witnessed across the country, I wanted to vote for this. I still had my reservations given last year's posture of the bill, creating and hoping not to create something that was non-egalitarian, and given certain causes of actions to a certain classes of people and things, but I got myself over that again after seeing what had been transpiring across these United States. However, without that amendment, I have some pause on section 3-2304 and may have to get myself, it's going to take a little time between now and third reader. So it's a possibility I may change my vote, but at this time, I'm still having to vote no. Thank you.
Just to appreciate and respect that because that's what this process is all about. So respect. Respect it. All right, so it's been a motion to move favorable with the what? Oh, actually, hold on. We have one more amendment that's being offered by the vice chair. You want to provide the context on that?
I can.
Sorry.
Why don't I provide the? So I'll just provide a little context. It's just boilerplate, technical amendment. As many of you know, over the interim, there was a question about whether people appointed to task forces can be removed from the task force. This simply clarifies that they can be removed from task force. And because there's a task force as part of this bill, as well as a later bill, we're just adding language to clarify if there was any legal doubt that people appointed to task force can be removed. So
This task force?
this amendment would apply only to this task force, not every task force.
Just this task force.
Yep.
Sorry, Senator James.
I just wonder, is it removal based on failure to attend 50% of the meetings? Or
No,
something like
it's
that?
so I'll let Shamari read the amendment.
And so a member of the task force serves at the pleasure of the person who appointed the member. At the task force's first meeting, the task force shall vote to adopt a code of conduct, providing for the acceptable conduct of task force members.
I would move the amendment.
Does not tell me. I'm sorry. Can you read it again? I apologize.
A member of the task force serves at the pleasure of the person who appointed the member.
So there's been a motion for favorable. I'll second it. It's been seconded. I mean, sorry, yes, the motion is on the amendment. So the motion favorable on the amendment. Do you need a roll call or is? Okay. Do we need a roll call or we're all good? All right, motion, all right, the amendment carries. Now the bills before you amendment, there's been a motion for favorable as amended. Because we're gonna handle that, but starting here. Yes. Yes, but this is just the first step. Yeah. Okay. Second. Roll call.
Vice Chair Waldstreicher.
Yes.
Senator Sidnor,
Still on 575, right?
That's right, yeah.
No.
Senator West,
Yes.
Senator Muse.
Yes.
Senator Folden,
Yes.
Senator James.
Yes.
Senator Charles,
Yes.
Senator Kelly,
Yes.
Senator McKay.
No.
Yeah.
Just for the record. just
Yeah,
get
go
a-
ahead.
Yeah. Yes.
Chairman Smith.
I was trying to get there.
Yes. All right. Bill passes 10-1. All right, now we're gonna go on to Senate Bill 10-1. Yeah, so we're gonna go to Senate Bill 23.
Senate Bill 23 requires that candidates for the judge of the Orphans Court appear on the ballot without party designation. This bill was in this committee last year, Senate Bill 195, and passed unanimously.
Is there an amendment or not?
No, there is an amendment.
Your amendment?
So this amendment removes section 8903, which governs when candidates for Orphans Court die being removed from the ballot. And that just removes that provision that if a candidate for Orphans Court dies or becomes disqualified more than 65 days, the name of the candidate may not appear. If the number of remaining candidates is less than the number of office to be filled, the office shall be deemed vacant. If the candidate dies or is disqualified 65 days or less, the name of the candidate shall remain. There was testimony at the hearing about the difficulty in printing new ballots within that short a time frame. I think that was the thinking behind the amendment.
It's a motion for a favorable. To adopt the amendment, sorry,
No.
on the amendment. All right, is everyone okay adopting the amendment? All right. Are there any further amendments? I don't see anything in the packet.
No.
All right, there's been a motion for favorable with amendment. It's been seconded. Roll call.
Vice Chair Waldstreicher,
Yes.
Senator Sidnor.
Yes.
Senator West,
Yes.
Senator Muse.
Yes.
Senator Folden,
Yes.
Senator James,
Yes.
Senator Charles,
Yes.
Senator Kelly,
Yes.
Senator McKay,
Yes.
Chairman Smith.
Yes. All right. Bill passes unanimously. All right, as amended. We'll go now to Senate Bill 75.
Senate Bill 75 increases from in excess of 10,000 to an excess of 50,000, the threshold amount for transfers by a personal representative, trustee, or conservator as a custodian for the benefit of a minor to require authorization by the court. There is an amendment to lower that amount to 25,000.
Second. Is everyone okay adopting the amendment, moving it down $25,000? All right. Now the bill is before you as amended. Motions second. Is everyone okay being recorded in the affirmative? Okay, bill passes unanimously. As amended. All right, we'll now go on to Senate Bill 164.
So Senate Bill 164 alters the definition of an interested person in the Estates and Trust article by establishing that a legatee ceases to be an interested person if the legatee's interest has been fully deemed, adding an interested person
a surviving spouse who has timely filed an election to take an elective share, and a person who timely files a petition to caveat a will and establishes that an assignee of a legatee or an heir is not an interested person.
Move adoption of the bill.
All right, motions for favorable. There are no amendments. Is everyone okay being recorded in the affirmative? Excellent. All right, next we'll move on. It says Senate Bill 164 passes unanimously. We'll now move on to Senate Bill 80.
Senate Bill 80 authorizes only an interested person or unpaid claimant rather than any person to file an objection to the appointment of a personal representative of an estate of a decedent.
Senator Westbrook.
It's another minor technical change. I move passage of the bill.
All right, it's motion for favorable has been seconded. Is everyone being recorded in the affirmative? All right, Senate Bill 80 passes unanimously. We'll now go on to Senate Bill 116.
Senate Bill 116 alters the prohibition allowing an orphans court judge to practice law, except when the matter is in the jurisdiction of the orphans court and related to the administration of an estate or guardianship of a minor. We passed this bill last year, SB 210, passed unanimously last year.
This bill allows attorneys in most of our counties to run for orphans court without having to give up their legal practices, except in the area of estates and trusts. I move favorable vote.
All right, there's been a motion for favorable. It's properly seconded. No amendments. Is everyone okay being recorded in the affirmative? All right, Senate Bill 116 passes unanimously. Now go on to Senate Bill 136.
Senate Bill 136 transfers from the county administrative judge of the circuit court for the county to the clerk of the circuit court for the county the authority to designate a deputy clerk to perform a marriage ceremony.
Senator.
Code.
Okay, got it. Just with the amendment, Senator Muse would like to be added as a co-sponsor. Is everyone okay with that amendment? All right. Now the bill's before you as amended. There's been a motion for favorable. It's been seconded. Is everyone okay being recorded in the affirmative? All right, Bill 116 passes unanimously. Oh, sorry, 136. We'll now move on to Senate Bill 159.
Senate Bill 159 authorizes the clerk of the circuit court of each county to keep an electronic record instead of a book for purposes of recording and indexing the discharge papers of a person who has served in the armed forces of the United States. The bill also broadens one exception to the mandatory denial of inspection of a discharge record by removing the restriction that applies only to a relative of the person as specified. Finally, in regard to authorized inspections of records, the bill requires a clerk of the circuit court to redact the social security number of an individual from any portion of the book or electronic record. There is a sponsor amendment. The amendments strikes the good cause requirements. If you look at I believe there is a printout. If you go to page 2 of the bill, as amended, a clerk shall deny inspection of the book or electronic record and the record and index in the book or electronic record, except to a party in a civil, administrative, or criminal proceeding in a federal, state court, or government agency, or the party's attorney who presents evidence satisfactory to the clerk that the inspection is related to admitting the record or a certified copy of the record and evidence in the proceeding. And so the exceptions were to a person of interest in accordance with the subpoena court order or for good cause shown. There was testimony during the hearing that for good cause shown standard might be a bit ambiguous. And so this amendment seems to address that concern.
Sorry. Isn't there a time frame that they were talking about before they would be allowed to be asked for?
Yeah, I remember that.
It was a passage of time, but I don't see it. Yeah, it was like 70 years.
70 years, right?
Yeah.
If the request.
Oh, it is?
Yeah.
Yeah.
Beautiful. Okay, thank you.
It's reading.
Was there a motion to adopt the amendment? Second, is everyone okay with that? All right, now the bill's before you as amended. Motions for favorable. It's been seconded, it's favorable with amendments. It's been seconded. Is everyone okay being recorded? All right. Senate Bill 159 passes with amendments unanimously. All right, 166.
Senate Bill 166 establishes the Waterway Incident Notification System Work Group. Senate Bill 166 is identical to SB 336, which JPR passed unanimously in the 2023 session. There is one amendment from the vice chair. It would add the same task force language regarding appointments and code of conduct as the committee added to Senate Bill 575 just a moment ago.
Is everyone okay with adopting the amendment? Motions were favorable on the amendment. It's been seconded. Everyone's okay being recorded right now. Now Senate Bill 166 is before you. Favorable with amendments. Is everyone okay being recorded in the affirmative? All right, Senate Bill 166 passes unanimously. All right, now we're on to Senate Bill 206. Sorry, Senator McKay. Okay, cool.
Senate Bill 206 establishes specific procedure by which the governing body of a condominium may grant a lease in excess of 1 year or similar interest affecting the common elements of the condominium for the installation and use of leased clean energy equipment.
Senator McKay.
Concerns about it. First of all, I think Senate Bill 206 is not necessarily good policy. Number one, the fiscal note, it talks about when it's explaining what it is. It says the bill establishes a specific procedure in which governing bodies of condominiums may grant lease excess of 1 year. My concern is, or a similar interest affecting common elements of the condominium. So I just tend to believe that this is just not solar panels. I know they talk about EVs, but it's more broader than that. Second of all, in the fiscal note, it talked about a task force, commissions, ownership, communities that was done in 2005. In that report, I can't find any of the recommendations that support what we're doing here in it. I tried to find somebody who would remember that from 2005, and Senator Dolores Kelly's the only one that was the name that I could. So second of all, in the testimony, the Climate Coalition, Montgomery County, their testimony did a really, really good job talking about the benefits of clean energy, the benefits of green gas reduction goals. But that's not what this bill is about. This bill is about changing the way the way that these condo associations are going to be voting on something. So second of all, in the Honorable Mark Ellerich's testimony, let me back up. The clean comment thing talked about that this was going to be no cost, lowering energy absorbance, increased value, and it was all benefits. So my thing is, why is it so hard if there's all these benefits? Why is it so hard? We have to lower the threshold. I don't know why we have to lower the threshold. So in their testimony, they talked about that having a volunteer condo board, they don't have the time or resources. Really? You don't have the time or resources to determine if this is a good thing or not, and we're going to lower the threshold because you don't have the time. It seems to me these same condo boards have had no problems increasing condo fees. They have the time to do that. So why does it apply here? Montgomery County exec, Mark Ellerich, there again, some great testimony. He said it was reducing barriers. However, the end result is to improve the process, and it's going to benefit all parties. I'm not exactly sure that you can benefit all parties when the minority party is, for lack of better words, exhausted when it's just a simple majority. Second of all, or fourth, I was looking up this thing called Science Direct, and it talked about the pros and cons of simple majority rule. And in there, it actually has an area where it talks about homeowner associations in a post-socialistic countries. Okay, I thought that was an interesting caveat there, but it is so as it talked about, it said there are many different rules about majority voting, simple and qualified. However, they may involve certain risks. And for the risk that I want to highlight is that a simple majority rule may cause hardship for low-income owners and force them out of the condominium because they can't afford the higher maintenance fees. So pointing that out, because this could put a hardship on those who are at the poverty level with their maintenance fee. Also, it requires that low-level requirements are in danger of repeating this in other areas. So why I'm going to vote nay on this bill is, first of all, I think it's a very, very weak reason to lower. When the testimony says there's not enough time to get in touch with the owners, we're going to lower the bar to vote on something because it's hard to get in touch with the owners. Second of all, I don't agree with County Exec Montgomery County that reducing the barriers and benefiting all parties. I'm not exactly sure that the minority party is going to be taken into consideration. And overall, the hardship for lower income owners is not respecting the minority interests. And I firmly believe that one could make the case that lowering this threshold is a form of voter suppression and why the most vulnerable population is at risk. Lowering the bar takes into consideration they don't have the time, that kind of stuff. So I also tend to believe that the statutory provision that's in place when it comes to voting in condominiums was established for a reason. And I'm not sure that lowering the bar is the right thing to do when the minority can actually be thrust out. Second of all, the third, fourth, whatever you want to say, or at 8, I'm not exactly sure that condominiums should be at the whim of like social media. If we made our decisions like social media and the majority rules, things would be going back and forth. And so I just don't think lowering the bar is the right thing to do. Thank you for your time.
Thank you, Senator. No, I appreciate the critiques. So I'll say, look, we've had a number of bills like this that kind of lower the threshold for various reasons, for logistics and moving things forward. But one is that the energy saving, the clean energy equipment is defined on the 4th page, lines 7 through 9. So it's limited to that definition. Second, there's significant notice and appeal rights that are still there with any condo association. So there is significant opportunity for the minority to participate in the process. And the third, there would be significant savings for your energy bill on this. And so not only are you going to have clean energy, renewable energy, but savings. And so through process rights, notice rights, energy savings, I'd move, continue to move forward with the bill. We've got a couple of people want to talk, so let's go with Senator James, then Sidnor, then Folden.
Thank you, Senator McKay. I felt like I was watching a newly admitted member of the bar. And so before I say anything, I'd like to ask a question of council. Because I don't want to go up to there and grab the condominium code, but I will if I have to. Currently, can a condominium group decide that this basically the bill? We get together, we'd like to make this particular exception, we'd like to bring it down to 51, we want to do it on this narrow provision. Can condominium boards do this currently by using the current process? Is there any prohibition against that?
There's no prohibition against that if they decide so.
This bill, because I don't have a lot of experience in this area, but I do know that I don't like one size fits all. I kind of like the condominium association legislation as it is, but what I don't understand, maybe the sponsored the bill could explain to me, since each condominium could do this, and then they can decide for themselves. So do you want to let me know why, sponsor the bill, why you, with that power already vested with them? And, why would we want to take that away from them, the individualized decision?
The reason why we've done this before in the past, not just with this bill, is because it's been logistically difficult to get that level of participation. And so the folks that are locked in and participate, it's easier to get to the 51% threshold than it is for the 66 or the 2/3. So it's just, yeah.
Well, here's my follow-up.
So
I apologize if I missed this in the year. I don't think I was in the room, but
Yeah.
I did read it very quickly. What other examples have we done this? Because I
3 or
wish
4
that, I
times
think,
in the
I
last
wish that
2
were
years
in
ago.
there, because
Yeah.
whenever I say something like that, I will put that information at your fingertips because I want to make it easier for you. But what I'd like to say just finally is I either want to just
Okay.
let Harper County out of the bill, or if you could give me a little more time, just if I could get that research and look
Yeah,
at
well,
it.
we did
Because then
it.
I could maybe, I don't want to be, the only one voting against it, but I also don't have enough. I would like to understand, I apologize, but I realize you didn't include that information. And
So
I'd
for
like to
instance,
see that.
I'll give you one more that I just pull off the top of my head, but I can give you more. But like during COVID or right after COVID, we did it for remote participation or like being able to hold the meetings
That
over
makes
Zoom.
sense.
We
But
did
that-
things like that. So that was one of the ones we did. that
But
I'm
that's a
thinking about.
little,
That's like a.
well, let me know if there is
That's what we did. We
anything
lowered the
other
threshold for
than
them to
an
approve that measure
extraordinary
to
once
meet
in a
and approve.
100-year situation, and
That's because no contact with.
right.
Senator McKay had talked about lowering the threshold, and I was trying to figure out where you were in the bill talking about the lower threshold.
Majority is 2/3. So that's 68.7 or whatever, and now it's gonna be 51%. It's just simple majority.
They were taking out 66 and 2/3 and putting 2/3 though, right?
No, they're.
Yeah, so
putting
that part
51%.
just wrote that part is just a,
51%.
just hold on. He's reading because there are some technical, there are like, there's just technical changes that they're making throughout the code. That's not a substantive change. They're just changing it from like the
Right,
numbers
so-
to the.
Okay, so that's,
Yeah.
okay.
That's
So
not-
I was trying to figure out where. Uh-huh.
Somebody to change their mind, the simple majority can tell them to pull it out.
Thank you.
Thank you, Mr. Chairman. I'll be brief. I just have a problem when we try to legislate something that we already have given the authority to do within the realm of responsibility of the HOA. So it doesn't matter if it's an HOA, it doesn't matter if it's a condominium association. These rules are in place, and maybe their lack of participation is people that just don't, that are saying no otherwise and don't want it to change. So with that, I would urge a non-vote, because the last thing we want to continue to do is legislate and take away the autonomy of the board that is elected to make these decisions and make these contacts to get these results that they're looking to do. You can go door to door if you choose to. There's methods in place. I think it's a bad move for the legislature to get involved in that type of activity.
No, I just, they can't go below the 2/3 threshold. I mean, I know they could legislate around, they could do their own policy, but they can't go, the statute says you can't go below the 2/3 threshold. If you want to do that, that's what the law says. So so when you say like there's an individual, that's what.
HOA, you just said. She just asked you, you said an individual HOA or condominium association can change the threshold on their own board with a 2/3 majority vote.
With a no.
You can
For the-
change
for the
anything
easement,
on an
no, for
HOA
the- for
board
the
with
granting
a
of-
2/3 vote. As long, so if you want to change it to this, they already have the autonomy to do that.
That's effectively the same thing, because
No.
to make the change.
No, you're making it that 51% could make, you're legislating that it would be 51% across the state. What I'm saying is not everybody, Harford County or other counties might not want this 51% threshold. Each individual HOA or condo association already has the threshold of 2/3. If they wish to change this, they have the autonomy within that board individually, whatever county, to do it on their own. By 2/3 vote, they can lower it to 51%.
Something narrow like this.
They can lower it to 25% if they wanted to.
Something.
So the threshold in the statute is 66 2/3 under current law. And so if you look on page 2 of the bill,
But what you said a minute ago is that they could change it with a 2/3 vote to 51% on their own,
Something narrow like.
on something narrow like this.
may not be understanding the question. It's, so under current law, you could grant easements for solar panels with a 2/3 vote. And so your question is, could they by a 2/3 vote lower
Lower the threshold
In this
of that easement in this narrow focus to 51% within their own HOA. And they can.
I guess they could.
They
yeah.
can. I've asked
So
them
that,
before.
so this bill is not necessary. We're legislating something and taking away that autonomy of the board.
We take 2/3 of this to do that.
And then they'd also need consent of the mortgagees, the banks. And so I guess the testimony was that that would be harder as well. And so they added the exception into the bill to the part, page 4, number 5, Roman numeral 4, a mortgagee or group of mortgagees may not overrule a vote to grant an easement under this paragraph.
Right.
So,
So they can't overrule it.
right.
It's just a matter of them making notification. They don't have to approve it because they can't override the board's wishes.
That's under the bill, they can't, but under the law, they could, as under current law, they would be able to.
Which is a problem because if you have a
So
larger unit, a larger building, then you could have several, you could have multiple, like a lot of different banks that are the mortgagees. And then that's another step that you'd have to know.
then it sounds to me like that's the change that should be made. That they can do it without their authority because they're working under the guise of the HOA body, the representative body of the HOA. If you remove that part that you're saying is written in there about that they can't change the outcome, but whatever it was that was making it so difficult, the notification, which I don't find that to be a big hurdle. You just notify them that you're changing it. So I don't understand that part. Am I wrong there, Shamari?
So you need the vote of 2/3, so.
No, I understand that. What I'm saying is that this bill would lower that threshold to 51%. And you're saying it adds in this notification clause for the mortgagee or the lender, insurance, all that, right?
The bill or current law?
The bill.
The bill.
Correct.
So that's my point. So why not do the mortgagee portion of the bill or that part of it as far as if that's the hurdle, but the taking away the 2/3, if each individual HOA across the state want to do that, then they can do it on their own by a simple 2/3 vote. Like, we don't need to legislate that. We're taking away the autonomy and the wishes of the board, of the community. And there's another way. They can literally go door to door to door to take these ballots if they choose to.
All right, well, that's a policy decision, not a dictator. So the policy choice here is to make it easier and to incentivize the, installation of clean energy and renewable energy that will lower costs for consumers and better for our environment.
But we're
I'm just gonna give it to the vice chair real quick and we'll go back.
Yeah, I don't want to diminish those concerns, which are real, but I do think we're accidentally making kind of a mountain out of a molehill here. And just for context, after that building went down in Miami, we passed a law here that required increased maintenance costs on all our condominium associations. Many of you have heard from condominiums in your legislative district about the burden that this is placing on them. But I'm glad that that's getting done. We had, a lot of people die in Florida. We are learning the lesson from that by requiring these improvements. And so the reason I add that context is because I actually don't think a lot of condominiums, even those ideologically who want to do this, are going to take advantage of this because their costs have increased so substantially because of the safety concerns that we've had in past. And so I don't think there's a lot to worry about here by passing this bill, because I actually think very few buildings will take advantage of this because of the cost that we put on them elsewhere. And so, my strong preference, Mr. Chair, is I think we should move forward with this. I think there are going to be few enough who take advantage of this that we can learn any lessons that we need to learn. And if we need to come back and relook at it after those few condominiums move forward, we'll have that time. But it's not like there's going to be a huge swath of condominiums that are going to move in this direction after this bill passes. So in that sense, I really strongly support the bill.
Not debating the merits of clean energy. I'm all for it. I am against centralized government usurping the autonomy of a longstanding, well-developed way in which we allow condominium owners the right and responsibility to manage their affairs. And I can imagine, because I see no governing principle here for why we'll make this exception here, but I can tell you that I could come back tomorrow and give you 20 other things that I think are really great. And some of you might actually agree with it. And we could start doing this. So it is very much a process and a principle. And since there is no governing principle as to why we're doing this versus something else, another agenda item, I don't think this is the right way to go. I don't see any precedent. Otherwise, I'm sure it would have been in my package or mentioned today with the capable assistance of the committee staff, but I'm pretty well aware that there isn't. So I think without a lot more thought into whether this is necessary, and whether I'd like to hear back from lots and lots of condominium groups all over the state as to what their comfort level is. I do not know if this just is coming out of Montgomery County, and then in which case I think it would be a lovely local bill. And I may well support this at another time, but not without hearing back from lots more people involved in living in condominiums and how they feel about it. And if this bill is going to go forward, I'm going to ask for an amendment to take Hartford County out, because I'm not going to make a decision for them unless and until I get to talk to them and see what their wishes are and what the issues are. Thank you.
Do you feel the same way for like just general utilities that are not
What do you mean?
renewable energy?
Huh?
Do you feel the same way for general utilities that are not renewable energy?
I just think the principle behind this bill so far,
Yeah.
and there may be a better one, but I don't see a governing principle in this bill as to why we're doing it here and nowhere else other than an emergency. And I'd rather, that is a big, to me, policy change. And I am, conservative in this sense. I think when things work decade after decade after decade, even a great idea, even my favorite pet project is not going to trump a well-designed process until a lot more information is gathered. And because there is no defining principle behind this, I don't know where this
But
ends.
for cable,
I don't know where this ends.
for cable or general utilities, would you be okay with the threshold being the same, or would you say that if someone wants to do a different cable?
Honestly, I don't have enough
two-thirds.
information. There
No,
is
just for general,
information.
what I'm saying is I'm trying to make
That's
the,
an individual property.
for utilities or for communications systems.
I don't even know what your question is.
So what should the threshold be for that?
That's an individual property owner's right
So-
to seek whatever utility.
No,
service
so
or
utility
does cable
services, it's in the statute, that the utilities and the communication systems can be approved by a majority vote. The same thing I'm looking to do here for renewable energy. So.
And I'd like to
so
know what
then-
the history of that was,
okay.
because there is no.
So then
there's
would
no
it make you more
comparison,
would it
Mr. Chairman.
make you more comfortable saying that you're putting these on par with other communication systems and utilities, that renewable energy should be put on par
What
with
if,
those?
I don't even know how that applies, Mr. Chairman. How
Yeah.
does that apply with the communication system? Like,
Because
are you telling
that's
me
a
that a
commu-
51% vote, a condominium association, everybody in that condominium association has to use the same internet provider?
Utility services or communications for like a gas line or for electricity and communication systems. It's a majority vote.
I don't even know if they're comparable, with all due respect. Again, I
Okay.
don't have enough information. I can get it, but I thought this was about leasing equipment, which I think is very different
Excellent.
than, utilities,
There's-
but I'd have to have more. research
Understood.
done.
And I'd like
Thanks.
to ask, like my colleague here from Harper County, that Frederick County not be included in this.
Yeah, let's do amendment.
So I've now spent 10 minutes reading this bill. Condominium law is really complicated. One reason why I didn't go into condominium law. So F1 on page 2 says there's a 2/3 requirement for the council of unit owners to approve leases affecting the common elements. The council of unit owners. Then F2 says the board of directors, which is a separate organization, can by majority vote approve leases in excess of 1 year for utility services. Then part 3 says the board of directors, again, that other unit of may again by majority vote grant leases in excess of 1 year for bulkhead construction. Then part 4 says by majority vote, the board of directors can settle an eminent domain proceeding. And now we get to part 5, which is new. And it combines the two. It says the board of directors by majority vote or the council of unit owners by 51% can grant leases on these clean energy equipment. So this is the overall rule seems to be that in general, the board of directors can do things by majority. But the council of unit owners has to have a 2/3 majority. That's the case until you get to this bill. And this bill says, when you're talking about clean energy, the board of directors needs a majority. That's consistent with other provisions here. But then it says the council of unit owners, only 51% of them can approve. So that's the change. That for the first time ever, we're deviating from the rule that 2/3 of the unit owners have to approve and substituting for it a majority of the unit owners. But it's complicated. But again, it says if we approve this, we could approve it and say the board of directors by majority vote can approve. And that's what we've done all through the rest of the statute. So maybe the way to solve this problem is delete the language about the council of unit owners here and simply say the board of directors by majority vote can approve this stuff, because that's the way the statute reads throughout.
As I read the bill, it's a lease. So why do you need this?
You know, could be.
So I can't speak to why that is that distinction, but the board of directors is generally a smaller body and, you know, selected by the council. Right. Exactly. And so. Right. And so I think the justification is so that you have most of the unit owners together and, or at least you have the unit owners, half of them, so that you can.
You're making the argument for the bill. When you say that, it's easier for to get a smaller group together. It's harder to get a larger group together.
I guess what I'm saying is the bill would not disrupt the system that we have had in place for some time with condominiums. If we just limited this to a majority of the board of directors, because that would be consistent with all the other provisions in the statute.
But it's easier.
Why can't the board of directors approve this clean energy equipment? Why wouldn't that work?
So, and here's the problem I see. You could have a board of directors. 7-3. You could have it 4 members who are against, 3 or 4, right? Which they don't want to do it. But then you can go out and solicit just over 51% of the rest of the body of the unit owners and pass it and take away the authority, I guess, of the elected board. So it's not necessary. What he's saying is very valid and not supporting the bill. It's actually deleting that one portion about that 51% of the unit owners. Then it would, if you deleted that, it would be consistent with the rest of the condominium law that's in place.
That's less than that. Yeah, it's less than that.
Sorry, you're trying to take it away from the body and give it to.
It's the.
I'm just saying that you're making it less democratic.
That's what it sounds
But
That's what
it's less democratic,
It's consistent with the law. It's 4.
but also less
The bill
democratic,
says
which
either
argues
one.
against what you're arguing the entire time.
Sound like it to me.
All right.
What? Do we know who the advocate was who specifically wanted the council of unit to be included in this as opposed to the board of directors?
Who the advocate was that wanted that?
Yeah.
There are two, forget the organization name.
Climate Coalition.
Climate Coalition, which is out of maybe Howard County, actually.
Okay, Montgomery County.
We'll make it a local bill.
I don't think it's a big deal one of the others.
Boards do not have the time or the funds needed to get in touch of all the unit owners. I just don't think that's not a,
Them if the board of directors already has that authority.
Favorable.
Second.
I will follow up with you all. It's been seconded.
Now, I guess we have a second, then we're in discussion because she made a motion to remove Harper County. Yeah.
Okay.
If you're not gonna give me more time, which I think is a very fair request, then I would like to exempt my county from now.
I'd like to hold the bill.
I just don't know about this bill, but I'm fine. I'd actually rather just get Hartford County out of this bill.
Yeah, I'd rather-
Then I just don't have to deal with it. And then you can have your bill and it'll go fast. Actually, I just want to exempt my own county out of it. Then the bill can go really fast because I don't want to hold you up. So that's fine with me. And then next year, once I figured this all out, which I will, I'll always can add Hartford County back into the bill.
So can we take a vote on the amendment to take them out and then vote on the bill and keep it moving? Right.
Why can't we make it a local bill as a pilot program and see how it works out? Because it's clearly Montgomery County's ask. No one else in the state is asking for this. It's two people from Montgomery County. I think that's a fair request.
Did what?
Maybe can we, again, you just said, either make the vote on a motion to take Hartford County out. And if you want Frederick County, anything else, but generally, whenever someone comes with a bill, you can say, no one asked for it. It's a bill. And or get the cross file and put the amendment on at that point so we can keep things moving.
Who is the cross file, Mr. Chair?
Who?
Because it's clearly a Montgomery County bill,
But-
so it should be a local bill.
Yeah, we're not doing a local bill. All right, so here's the deal.
So we're gonna force this.
Yeah, all right,
Okay,
I've got,
now that's making my point.
here. I've got 1, 2, 3, 4, 5, 6. All right, Senator James, out of respect for you. No. You're not. I've got the votes to get this bill out of here. It's fine. But I want to work with you on this, but we got the votes to get this bill out. I'm gonna work with you on this. So we'll hold the bill for next week.
Great.
We are good.
Well, at least it's out of respect for you.
No, we're gonna do it.
My button's still flashing.
I'm your lawyer. You meant to-
It's just another example that they're gonna force a bill.
All right, so
It's Montgomery County based.
Senator from Frederick, we've got one more list to go through, so we got one more vote. The-
I know my staff.
Never seen such.
My name.
All right. I guess we know what bills are not gonna be on the list next time. All right, Senate, so let's go. There's a motion for an unfavorable for, can we do this all by consent?
Withdrawn, yep.
Can we do this all by consent?
Yep.
So, is most of our, everyone okay? All right. All right, we are adjourned.